Welcome to today's session. In this session, we are going to understand the little nuances of the Insolvency and Bankruptcy Code. So let's get started. Look, these issues of insolvency and bankruptcy are not new. They have been there since very long. So naturally, if there are problems, there are legislations addressing those problems as well. For example, to deal with corporate insolvency, Companies Act of 1956, Companies Act of 2013 and SICA had provisions. Alright, but however the SICA is repealed now anyways, and for retail debt there were provisions under SARFAESI Act and RDDBFI. This RDDBFI Act is famous for two things. One is because of DRTs or Debt Recovery Tribunals. They came into existence because of this act. And the second issue is FRDI or Financial Resolution and Deposit Insurance, the famous bail-in clause. This is related to the provisions of RDDBFI. Now one might wonder what happens to these laws when IBC has come into picture, right? So what happens is IBC has a clause in section 238, okay, according to which it will have an overriding effect on other laws. For example, there is a clause in Companies Act 2013 about some insolvency proceeding. Okay, the same topic is dealt with in IBC also. So the clause which is there in IBC will have an overriding effect on the clause that is there in Companies Act of 2013. So similarly, any provision which is there in IBC will have an overriding effect on any other law pertaining to insolvency and bankruptcy, let it be Companies Act of 2013 or SARFAESI or RDDBFI. But that doesn't mean that these acts like Companies Act of 2013, SARFAESI or RDDBFI stand repealed. No, only the provisions relating to insolvency and bankruptcy, IBC will have an upper hand. Now let's quickly understand the process of insolvency and bankruptcy. How is it carried out? See, first, either the debtors or the creditors can go and ask the NCLT to admit their case of insolvency. Alright, so debtors or creditors, both of them can go and approach the NCLT, and here RBI can directly go, can give directions to the NCLT to admit the case. Then if a debtor or a creditor goes to NCLT, then NCLT gets 14 days to decide whether or not to admit the case. But if RBI goes, then NCLT has to accept the case. Then the NCLT, if the case gets admitted, then what happens is immediately the board gets suspended. The board of the company gets suspended and an IP professional, insolvency professional gets appointed. Okay, there is a little discussion here. An IP professional, first they'll appoint a interim insolvency professional, then there will be a final insolvency professional. Okay, there are little nuances, but broadly you remember that there will be an insolvency professional appointed and the board will be suspended. Earlier what used to happen is this board used to continue, but the problem is the board only is the problem. Because of them the company went insolvent or bankrupt. No. So what is the point in continuing with the board? That's why the IBC says that when the NCLT accepts or admits the case, then the board stands suspended and insolvency professional will take over, or an insolvency professional agency, either an IP or an IPA will take over. Then they will appoint a COC or Committee of Creditors. Alright, it will actually replace the board. It is COC, Company of Creditors. Here also there is a catch. See, creditors are of different type. For example, there are financial creditors, there are operational creditors. Okay, financial creditors are those who have collateral, okay, as guarantee. But these operational creditors do not have the collateral with them. So this COC, the Committee of Creditors, will only have financial creditors on board and not the operational creditors. A COC will be formed and the COC will come up with a resolution plan within a time frame of 180 days, which can be extended up to another 90 days. So totality it can come up to 270 days. So within this 270 days, the COC has to come up with a resolution plan and everybody has to agree upon it. Okay, there are certain percentages again in it, you don't have to know that in detail, but resolution plan has to come out within 270 days. If a resolution plan comes out within that time, then yeah, they will continue with resolution, there will be resolution, there will be the further step. But if no conclusion comes out or no resolution plan comes out of it, then the company will go to liquidation. Okay, all the assets of the company will be sold off and the money will be distributed according to the waterfall arrangement which is there in the IBC. So these two things will happen. See, the good part about IBC is it is very timely. The resolution happens within 270 days. The resolution plan comes out within 270 days. But after this, if there is no resolution plan, if the company goes for liquidation, there the problem starts. For liquidation process, there is no time frame. A certain time frame is not there for liquidation plan. So the timeliness of IBC code ends here with resolution, and liquidation is going to take time. Otherwise, IBC in totality is a good code which is replacing the time-consuming older legislation. After the IBC came into existence in 2016 and after the changes were made to IBC in 2018 through an ordinance, a lot of change has occurred in the insolvency procedures happening in India. The process has become very timely and efficient, and this you can see it is reflected in the ease of doing business rankings of India. See, if you can see from 2013 to 2018, consistently in the beginning the ranks are 139, 132, 140, 134, 131. But suddenly from 2017 to 18, there is a jump of 30 ranks. So this jump of 30 ranks is the partial contribution of IBC. Actually, a very huge contribution of IBC is there in this jump of 30 ranks from 130 to 100 of India in the ease of doing business ranks. Okay, this has helped India gain a very good name world over regarding the insolvency procedures. So with this, we have come to the end of today's session. Here we have mentioned a few model questions. Please answer them. See you in the next session. Thank you.